Hey everyone, welcome back. I made it back here. Hopefully some of you are back here with me for day 2, episode 2 of Ask a Lawyer Live. I'm your lawyer, David Brannen. I focus on employment and disability cases exclusively. Today we're going to be talking about long-term disability. That's our topic of the day. Yesterday was CPP disability. Tomorrow is going to be a employment wrongful dismissal topic. So welcome back, everyone. Let me just double check. Does look like my mic is working today. We got a little shaky start yesterday with no mic. And I'm not seeing anyone saying my mic isn't working. So we're good to go. Let me bring up today's topic is long-term disability insurance forms. Now, before I get into that, I do want to remind everyone that how you ask questions is by putting your question in the chat wherever you're watching. Understand that this is a public presentation and a public live stream, so any information you put there will be viewable to others. It can be posted up on the screen, so just keep that in mind. If you want confidentiality, you would have to modify your name as it appears in either your Facebook account, which is probably not possible, or in YouTube. I believe you can modify your YouTube name so that it doesn't appear as your real name, if that's a concern to you. I also want to remind you that on Thursday, we'll be doing a call-in show where I'll be able to take calls from people so we can talk back and forth, and I can give a more in-depth consultation. Again, these would be a legal consultation, but they are done in the public forum, so there's not confidentiality. So just keep that in mind. If you need a confidential assessment or a confidential consultation, that's something we'd have to do offline. Alrighty, let's dive into this thing. So insurance company authorization forms. So we get a lot of calls about insurance company authorization forms. People get quite concerned about them, whether you have to sign them, can you refuse to sign them, and if you do refuse, can the insurance company cut off your benefits? So we today are going to go through this. Let me get up my slide here. Bear with me. I'm still learning how to do this. Here we go. So let's take a look at this. The goals today, as I've just said, are you required to sign? What happens if you refuse? And how can you protect yourself from overbroad authorizations? Those are the ones where you're authorizing them to get information from everyone, basically, the whole world. Those are the ones that get people worried. So let's start by just talking about what is an authorization form, just so we're all on the same page. This is a form, a paper form, or it can be electronic, that you sign that authorizes the insurance company to get information from third parties. It's personal information, and it allows this form will allow third-party organizations or people that have your personal information to disclose it to the insurance company. That's what we're talking about when I say an authorization form. Now, why are these forms needed? They are needed because in Canada, we have privacy laws that do not allow businesses or professionals to disclose. If they have personal information on a customer or a person, they are not allowed to disclose that personal information to third parties without the consent and authorization from the person who has the personal information. So that's why these forms are needed, because if they weren't there, people would not be able to provide information to the insurance company. The other thing with professionals like doctors and therapists and the like, they also have a obligation to maintain confidentiality. So separate and apart from privacy laws, they have their own ethical duties. So they would need you to give them authorization in order to disclose your personal information, because they have a duty of confidentiality just through their professional codes of conduct. And most importantly, why these forms are needed, as we'll go over, there are certain obligations you have under a long-term disability insurance policy as the insured person. There's some obligations that you have that you will not be able to fulfill those obligations unless you sign some of these authorization forms or give authorization for the insurance company to get information. That's going to be a key part of this that you will need to keep track of here. So, okay, authorization forms are necessary to meet some of the contractual obligations. That's what I've just said. Some of the things where this comes up is under an insurance policy. We're talking mostly group insurance policies here, but it really would apply to almost all of them. There's either group or personal ones, insurance, but they all require you to give proof of your disability to the insurance company. Now, it's pretty hard for you to give proof if you don't authorize any of your doctors or anyone else to give information to the insurance company. So it would be not possible for you to prove your disability claim if you don't authorize doctors and other people to give information, release information to the insurance company. So without authorizations, you just can't meet your obligation to prove your claim by providing medical information to the insurance company. So keep that in mind. There are other obligations that you have through the group insurance policy other than just proving your claim. There are usually clauses in there that allow the insurance company to require you to undergo independent medical examinations. So that's a situation where they pick a doctor. They're allowed to pick a doctor of their own choosing to send you to for an assessment for the purposes of the insurance claim. That's not something that's often something that is required by the policy. It's one of your obligations. So if you refuse to do it, that would be grounds for the insurance company to deny your claim, even if you otherwise would meet the disability criteria. If you don't follow all your obligations under the group insurance policy, they can deny your claim, even if you would be disabled under the plan. So how these independent medical assessments, how they work is they can't do the assessment. So the doctor doing the medical assessment on you, they require your consent and authorization in order to get information from the insurance company. So the insurance company needs to provide information to the doctor about you. The doctor needs to communicate with them about your information. So you can't even do these assessments without giving authorization. So this is another example of where authorizations are needed. There can be some debate on the extent of the authorizations that you need to sign, but often I just recommend people sign what they need, what the insurance company needs in order to facilitate these assessments. Certainly, refusing to sign authorizations will throw a wrench into the gears of the insurance company trying to set up one of these independent medical assessments, but it's usually not a good idea for you to use that because you just kind of shoot yourself in the foot. If you make it so it's impossible to do this assessment because you won't authorize the exchange of information, then that could just be a breach of the policy and you can end up being denied just for that. Another example closely related to an independent medical assessment is when the insurance company sends you for treatment. Now, some people say, well, they can't really send me for treatment. Well, that's true. You can always refuse to go, but under some insurance policies, it's written in there that they are allowed to recommend rehabilitation and that you are obligated to do it. So again, you can refuse, but not really, because the refusal will mean that you are unable to, that they can sort of cut off your benefits because you are breaching a part of the policy. So again, in order for the insurance company to arrange it, they need to be able to contact a provider about you. So they need an authorization from you in order to talk to a provider about setting this up. They need to be able to get reports back from the provider. So let's just say it's a physiotherapy clinic. They need authorizations for the clinic to send information back to the insurance provider and so forth. So again, that's a situation where you would need to sign an authorization to allow you to meet your obligations under the policy. Lastly, here is this idea of good faith. That's a term you will often hear. That is because the courts have determined that long-term disability policies are a special type of contract. They are a contract that requires utmost good faith on behalf of both sides. So the insurance company has a duty of good faith to you, and you have a duty of good faith to the insurance company. Good faith means that you will use your best efforts to meet your obligations under the policy, and you will not try to trick or do things to frustrate the policy intentionally. So good faith, a judge looking at this. So if you ever got into a dispute over an authorization form related to an independent medical assessment, the insurance company would really a judge would look at it to see, were you really acting in good faith, or were you using this as a technicality to just frustrate their abilities to get an independent medical? So you can run into problems there. Let's look at the characteristics of these forms. Probably if you're on this live stream here, that you have run into these forms. Maybe they come in all shapes and sizes. We certainly use them, so we can't run your case. You have to give us authorization as your lawyers to get information. So one of the first things you do when you hire a firm like ours is we get you to sign a bunch of authorization forms that I then send to the insurance company, authorizing them to speak to me. So that's an example of how authorizations work. Ours are pretty simple and straightforward, but there are all types. What you want to understand about these forms is they can come in, they have different characteristics. So the best type of form, what they actually teach you in law school when giving these authorizations, is the more specific it is, the better. Legally, it's better legally to have it specific, because then there's less room for debating over what's covered by the authorization. Specific means like a specific duration that it will last, specific third party that you're giving it to. So you're not just saying all doctors, you're saying Dr. Smith. So it's specific to the third party that will be disclosing. And that those are examples of a good authorization would be, and then specific about the type of information, like my medical records, to speak to so-and-so on the phone, like specific to the type of disclosure, the duration, and the person or organization. Those are the best types of authorization forms, and that's usually what you want to be looking for in these cases. The bad types of forms are these generalized forms that are open-ended in terms of duration, how long they last. They're open-ended to who they apply to. So it might just say any person, I authorize any person to give information to the insurance. That type of form is not good when they're very general about either the duration, the organization. It's not really specific to an organization. It's not specific to the type of information, like any and all information. Like these types of things are not good for these forms. They're not good for you. They're generally not good for the insurance company either. Most lawyers will argue to get the narrower and the more specific the form, the better, because there's less likely to be any disputes over whether the disclosure in question was covered by the form. It is a problem for insurance companies to breach your privacy rights. So they're not really interested in doing that. It's just not worth their time to be fighting these and having privacy commissioner investigations and all these. They really don't. They want to avoid that. They're trying to go through the easiest path from A to B. So they would prefer not to do that. But there are other considerations on why they still try to use these general forms. But in a perfect world, the specific forms are better for everyone involved, including the insurance company. Now, the other types of forms that you will see, and we're going to talk about them today, but I'm also going to do a future talk on these as well. There are standalone forms. There are standalone authorization forms. That is what you think. It's just, that's all it is. It's the only purpose of this form is that it authorizes someone to disclose your personal information. That's all the form is. Those are, again, the best types of forms and the best types of authorizations for you to sign. There are other types of authorization forms, or what I would call an integrated authorization. The authorization itself is integrated into a form that has other purposes. Often you will see this if the insurance company wants you to fill out a questionnaire, sometimes an application. There's some other things going on in the form, and then at the bottom they tack on this authorization component. Okay, they're kind of slotted in. Sometimes they're we'll go over here in a second, but they can be a little bit, from my point of view, they're a little disingenuous, sneaky, be a good word. They're sticking them in there because they come at the end of a questionnaire that you have to fill out, and there's a signature line. So they know that psychologically they're putting pressure on people to sign it, because it's sort of like you're signing that this is the questionnaire you just did, but it's also signing it for the authorization. So it kind of confuses and conflates these things. So I do not like these integrated forms that include authorizations. And insurance companies, they're not as good for them either, because they're more likely to not hold up in court, or they're less likely for another third party to accept a form like that as well. So what are your options? We get asked, do I have to sign this? What should I do? It's always a little bit stressful to decide what you want to do with these forms. Ultimately, there is no law that requires you to sign forms. You have the privacy rights trump all, and you can just say, no, I'm not going to sign it. Now, the problem with that is that that will conflict. So you do have the ultimate right not to sign them, but that will conflict with your obligations under the contract. So again, outright refusing to sign forms, authorization forms, can mean that they can legitimately deny your disability claim on technicalities, which you don't want. You never want to be denied a disability claim on technicalities. If you're going to be denied based on medical evidence, whether or not you're disabled or not, that's fine. But these other technicalities, you don't want to be fighting more than one battle. You want the battle over whether you meet the definition of disability. You want the battle over whether you were right or wrong to not sign a form. It just diverts the attention, and it gives you two reasons why you could now lose the case. So things you can do are, number one, don't sign. Number two, just strike out the sections that you don't like and initial it, and then they won't apply. A court would understand that when someone signs something and things are strucken out and you've initialed it, then if you can prove, again, usually there's not going to be a dispute over this, but if you can show that that's what you did when signing it, that will be interpreted as you are rejecting those components and they do not apply to what you're signing. Another option is to also, kind of in addition to striking out, you can write a note clarifying what you want the authorization to include or exclude or limited. You can do that. It's legal to do that. It's legal to scratch things out, write things, just initial that you did it, so there's no dispute who did the crossing out and things like that, and then sign it. They will be that form, like in terms of interpreting what you've authorized, that will now be taken into account. So you have the power to be able to do that. The other thing is, if you're given a questionnaire, one of these integrated forms where you have a questionnaire, one of the options you can do is just fill out the questionnaire and just sort of cross out. Just don't even deal with the authorization component. Really, what they want with the questionnaire is the information in the questionnaire, and the section on the authorization is just there to kind of throw it in there is a freebie, trying to get it. So why does the insurance, why do they care? Why do they want these why are they constantly throwing in these tacking on these authorizations and things? A lot of it boils down to, that is my last slide. A lot of it boils down to convenience. They just want the most convenient approach to this. It's more convenient for them when they can get you to sign one form and they don't have to keep coming back to you. It's more convenient for them to include a form that it covers everything. That way, if at some point one of their people discloses information inadvertently, maybe, or on purpose, whatever, to some other person, you're not going to have grounds. Well, you'll have less grounds to go after them as a privacy breach because you've signed these general authorizations that cover everything. That's kind of what it is. Think of it as a risk management. It's not so much, people envision it that there's these people plotting at the insurance company. They got these forms and they're like, wow, they're going to go and get records. Like, that is typically not what is going to happen in my experience. They are not taking these broad forms that you sign and running around to Revenue Canada, to this place, that getting out, like, that is generally not what is going to happen. The reality is that these broad forms that are often tacked into tacked on the bottom of a questionnaire, Revenue Canada, like a lot of organizations aren't going to accept that. If that was sent to them to say, yeah, here's their authorization to disclose this information, they're going to look at that. They have their own risk management. They're going to look at that and say, no, use our form. And they'll send the insurance company. That's the funny thing about this. Everyone has their own form. So they'll send the insurance company and say, no, you have to get this form filled out for our hospital or whatever. We're not going to accept this broadly worded thing because we don't want a complaint against us that we should not have disclosed this. So think of it more that this is a risk management from the insurance company's point of view, that they have some grounds that if they make a mistake and disclose information, that they've got some reason to say, oh, you authorized it. Okay. So just keep that in mind. The other thing is, it can be more convenient for you. Giving broader authorizations to the insurance company allows them to manage the case with more efficiently. Again, remember, like in today's world, the insurance company is going to be not they're going to be dealing with other outside parties about your case. They have consulting doctors that don't work for them. They might hire an outside agency to book the IME for them. So there's all these different intermediaries that are involved in the industry that if having the authorization, they need a broader authorization in order to facilitate the administration of your claim. And if you want that to be done efficiently and quickly, then these broad authorizations allow that. The opposite is that you force them to do, and so again, it's efficient because they have a broad authorization, they get it signed once, and now they can do everything. If on every case they have to do these custom authorizations and go back and forth with the people, there would be no time for the insurance to do anything else. Maybe that's a bit of an exaggeration, but that's how they would look at it. We're wasting all this time negotiating these things. Like, when are we going to move this case along? Everything is stuck, and it will take longer to administer these cases, these claims. So keep that in mind. In some situations, it's just better for you to give a broad authorization if you just want your case to move along smoothly and efficiently and with as less hands-on for you. But if you don't want to go that route and you don't want to sign certain authorizations, there are opportunities where you can, in some cases, refuse to sign the authorization and just say, oh, don't worry, I'll get you the information. If what you're asking the authorization for is my family doctor's records, well, don't worry about it. I won't sign the authorization, but I'll go get those records and get them and provide them to you. That's a situation where you could refuse an authorization and still get them what they need, and you wouldn't be in trouble of having your benefits cut off. Now, oftentimes, depending on your medical condition, it might be better for you to have them take care of it. So often what they'll do is if you sign the authorization, they will write to the doctor and chase the doctor to get the records. Sometimes they'll even offer to pay for the records if you give them the authorization. Okay, and that's something else you could negotiate. If they say, well, we want you to sign this authorization, you could say, well, I'll do that as long as you pay for the records you're ordering. And they might say, yeah, sure, we'll do that. They might say no, because ultimately you're supposed to pay for them under the contract. But that's another thing you could do, is get them to agree to pay for the records. All right. Let's move along here. Let's look at some specific forms. Well, actually, before we do that, let's see if we have any questions here. Take a little break, get a little drink of water. We're going to look at some specific forms and talk about it. But first of all, let's look at some questions. So the first one is this from Drew. I've been on LTD for a couple of years. Let me get my mic here. I still have benefits through my employer, but sometime I will be terminated. Question, is the employer obligated to give me severance? Okay. All right. That's a little bit off topic, but I will answer it. And I can deal with any of these questions like this at the end. But generally speaking, it depends on where you live, what province you're in, and on whether you're going to be terminated and whether you're owed severance. Actually, to be honest, Drew, come tomorrow, because this is the actual topic of my talk tomorrow. What happens if my employer fires me or terminates me while I'm on long-term disability? So you know what? I'm going to pause on this, and I don't want to give away tomorrow's presentation because that's what I'm going to be talking about, this exact question. All right. But generally speaking, just to answer your question a little bit, if you do receive severance from an employer, that can affect your LTD. They can stop it for whatever months that the severance applies to. So just give you that heads up. All right, let's look at another one here. Okay. Oh, so this is another one that I'll deal with tomorrow, or I can talk a bit about it at the end. So this is another one dealing with what happens if your employer fires you while you're at work. So I'll talk about that at the end. All right. Okay. All right. So these questions are they're not related to the authorization forms themselves, which is fine. I can touch on some of these at the end, but these also all fit for tomorrow's talk when we're going to be talking about, can my employer fire me while I'm on long-term disability? Okay, let's look at some specific forms here. Let's have a look. All right, this one. So this, boy, I'm having a hard job seeing that. Let me blow my screen up here a little bit. Hopefully you guys are going to be able to see that all right. This is what I would call a good example of a specific form. So this is a letter written from an insurance company to a doctor asking for the doctor's records. This is a good example of a specific form that the person signed that allowed for very specific person and very specific information that's being disclosed. So you can see here, the specific information is copies of all clinical records. Okay. And the person is specific to this doctor. And you can see the authorization they're using is on page 2 here. It's this little thing. It looks like they cut and pasted that from somewhere, honestly. But it just says I authorize my doctor to provide my personal information. So it's very specific to the doctor, and which would in this case be the family doctor. Very specific. This is a good form. You should have no trouble signing something like this if you want your insurance company just to be able to write to the doctor to get the records. Now, some lawyers will tell you, look, this is fine, but it also, this type of authorization also allows them to call your doctor, ask your doctor questions. And sometimes that can work against you. It can absolutely work against you if they're talking directly to your doctor. So again, a form like this may be limited to, I have to look and see what it's limited to here. It's hard to read that. Yeah, I think this is broad enough that it would allow the doctor to call and speak with the insurance. You could have adjusted this to simply say that it's only for disclosing my medical records and does not include conversations with the doctor or answering questions and that kind of thing. You could put that on there if you wanted. I don't always recommend that. Sometimes I recommend the path of least resistance for a lot of these situations, but again, it will depend on your situation. All right, so this person, got a question here. This person's saying, are Manulife forms standardized? If so, what do you think of their form? They're not really standardized. They're constantly changing these forms, and they don't have just one form. They have a bunch of different ones. So there's all of the big insurance companies have problems with their forms because they will use these integrated forms that I don't like. They all use those, all the insurance companies. So I think there's problems with all of the forms that they use, and it'll be on you to decide when you're just going to sign the forms and when not to, basically. All right, let's look at our next one here. So this is a good form. So this next one this is what I would call, this is not a fully integrated form. So this is still a form that is a standalone form. Like there's not like a questionnaire attached to this or anything like that, but this does include things outside of asking for an authorization. This is one of these forms. I don't like these forms. For example, this one, it's asking for declarations and things that you do not have to give. Someone actually called our office. I didn't have a chance to get they wanted me to review their form, but I didn't get it in time to include it. But they were asking about like a fraud notice. Sometimes these forms will ask you to agree to a fraud notice, that you understand that it's fraud, to lie on a form and to do all this stuff. No, you do not have to sign these fraud notices and all these things. Okay. It's not required for you to sign that type of stuff. There's a lot of pressure on you because people say, well, unless you're doing fraud, why wouldn't you sign that? Well, it's not really the point. Your obligations to the insurance company are already dictated by the contract itself. You do not have to sign new agreements that you're agreeing to things or acknowledging things. You don't have to do that. There's no legal basis for that. So you don't have to sign those aspects. This form here has an element of that because it's asking you to confirm. Like this is what I don't like. I confirm that the information in this form and any further verbal or written statement provided by me in the future. First of all, come on, man. Like that's ridiculous. They're going to get you to sign that any information. Well, I guess let me finish it off here. Any information provided me in the future is true and complete to the best of my knowledge. That's not terrible, I guess, because it says to the best of my knowledge. So that's not as bad as I thought. Sometimes they leave out to the best of my knowledge. If that's not there, then this is completely inappropriate. You're going to make honest mistakes and be wrong on some of your information. And so, but if at the time it was to the best of your knowledge, that is actually lawyer language that would make this not terrible. But I don't like these things where they're asking you to declare, to like pledge your honesty and all these things. It's not something that needs to be on these forms. They want it in case they want this to be able to produce this at trial. If they ever think that you have been dishonest or something, they want to be able to whip this sheet out and hold it up to the jury and say, look at this, you signed this, like it's more theatrics than anything. And you don't have to sign these parts of it. So again, these parts of forms I don't like. You can just cross out these types of forms, these aspects of a form. Because again, this is a statement, authorization, and certification. Like it's an integrated type form where they're trying to do multiple things here beyond just giving an authorization. And I would just tell people don't sign these parts and say that a lawyer told you not to do it. If they're asking why not, you say, well, I was at a webinar and a lawyer said don't do that. Again, I can't always advise people what to do without seeing your specific form and knowing your situation and knowing what implications it may have for you personally. So again, I'm talking generally here. You have to be very careful about taking general advice like this and applying it right to your specific situation because things can change. The law is very fact specific. But as a general rule, I do not like these where they're asking you to pledge your honesty. Okay. It's kind of a ridiculous thing to do. It's not legally required. I mean, you could come to them with a form and get them to do the same thing and they wouldn't sign it, right? You get them to pledge their honesty and loyalty and all these things. They would probably look at you like, what are you doing? It's the same thing. It's just as ridiculous for them to ask you to do it. This then has this part here. So this is a more general type authorization, but it's mostly limited to your employer, group plan administrator, healthcare professionals, healthcare institution, pharmacy, and other medically related. So this one is not too bad. Insurer, administrator of government benefits, or other healthcare. So this one here, this is not terrible. This is more general. This is not as good as the first one. So this form was saying that you're authorizing the administrator, all the administrative structure around the insurance company you're authorizing. You're authorizing your medical providers and benefit providers. So things like CPP and things like that. This is not terrible because it is at least limited to the world of things that are directly involved in administering your claim. So it's not terrible. It's not saying, oh, sorry about that. It's not saying like anything at all. It is limiting it to a certain extent to things needed for the administration. It's still pretty broad. You'd prefer not to sign something like this, but again, these types of authorizations are often needed in order for the insurance company to administer the claim and deal with some of these agencies and different types of things. Well, it's not any agency, it just says government benefit providers. So usually that just means CPP disability. Says here, I acknowledge my medical information will not be provided to my employer unless my consent explicitly allows that. So that's the other thing. You want to make sure that they're not just going to give all this information to your employer. You often don't want your employer knowing all the details. And then this part, nothing wrong with this, just saying a photocopy of this is valid. And there's more acknowledgements down here. So again, this is another example of a form that I don't really like when they put these other pledges and things in here. And it is more of a broad authorization. But again, this is more geared towards allowing the efficient administration of your claim. So it's not completely out of bounds in my mind. All right, let's look at another one. Last one. I was trying to find a really bad one and I couldn't find it in time to get it on here. But I've seen some really bad ones in my life. This is not an example of the worst at all. Here's an example. So this is an integrated type authorization. I didn't put all the pages, but you can see like this is section 8, section 9. So there's 1 to 7. This is an example of where you get a questionnaire to fill out as part of your approved disability claim. And then at the bottom of the questionnaire, they tack on this authorization and certification, right? They're asking you to agree to things. So it's called agreement, authorization, and certification. So asking you to agree to things, you don't have to agree to things. You already have an agreement. The agreement is the long-term disability policy. So whenever your ears should perk up, whenever they're asking you to agree to new things, because legally you're not required to agree to new things. All the things you already agreed to are in the policy. They shouldn't be asking you to agree to new things. Authorization is fine. We just have to look at like, what am I authorizing and is it too broad? Certifying, again, depending on what they're asking you to certify, these are again pledges of honesty. Like, it's okay to certify things are true to the best of your knowledge. That's if you put that caveat there, then usually you are fine. It's when they want you to swear that it is true, and there's no caveat to the best of my knowledge, because you can be honestly believing something and later find out you were wrong. And now, once you find out later you were wrong, and now you're trying to change it, they can make it look like you're lying then or you're lying now. You're changing your story, that kind of thing. So this is an example again of where we get into down here. This one goes a little further than the last one we looked at, so it's a little broader in terms of what it's asking to be authorized. It has the same, it's very similar though. It has this pledge here at the top of that you are, yeah, it does say the best of my knowledge though. So again, it's not the worst. The worst ones are then they don't say to the best of my knowledge. So this stuff is not terrible. Like, you wouldn't be wrong for signing this. I wouldn't tell you that you should never sign something like this. I'm just saying that they're asking for things that you don't necessarily have to do. Just be aware of that. And this is quite a broad authorization. Normally my advice when you get a form like this, that the primary purpose of this form is for the questionnaire information. When the primary purpose is for the questionnaire information, I would just cross out this in most cases. That's what I would recommend usually people do. It's just, this is not integral to the form itself, so you can just cross it out in most cases. It's not, the purpose of the form is the questionnaire. You can fill out the questionnaire, sign it that you've done the questionnaire. Even if there wasn't a signature line, you could just sign it and date it and print your name under there. So if you can't read your name, sign it and date it, and then just cross out this tacked on authorization. And you could write here, if you need any specific authorizations, just contact me and I'm happy to sign a more specific authorization. You could put something like that. If they come back to you and say, well, no, we need that, like, they will put a lot of pressure on you sometimes to say that you must sign this. And again, people feel like it's blackmail because you're on an approved claim. You get this questionnaire. Many people worry like, well, it's fine for you to say don't sign that. What if I don't sign this? Can they cut off my benefits? Well, yes and no. Like, they really can't. They couldn't cut off your benefits just because you didn't sign this. But there may be more to the story. Like, maybe they need an authorization in order to coordinate with some outside party they're working with, like to coordinate something, and they need you. So you could, that's why you always want to say, I'll provide a more specific authorization if you have a specific need for information. Put that in there, and then that opens the door that they can come back to you and be more specific about what they want. Usually when they're signing this, they don't have anything in mind they want. They just want this general thing on record because it's, like I said, it's more expedient for them. It's more convenient for them to have that done. Alrighty. Here's another question. Just bear with me here. Can signing these forms allow insurance companies to look at your health insurance claims, like pharmaceutical claims, chiropractor, etc.? Yeah, yes, they can. Not like, it's very hard for them to go behind your back and sneakily do things, quite honestly. And in my experience, that is not usually what is happening. The sneakiest thing they're going to do behind your back is arrange surveillance and put you under like insurance surveillance, where there's an investigator, sitting in a car outside your house or photographing you at the mall or some kind of thing like that. That's the sneakiest thing they're going to do. They're generally not going to be sneaking around trying to get information out of all these other places like health claims and pharmaceutical claims and these kind of things. Normally, if they're going to be asking for that stuff, you're going to know about it. They're going to be talking to you that we're going to write and get this information. That is the best practice that most of these insurances are going to follow. So, but the question here is, do the forms allow them to do it? They can allow them to do it. Yes, they can. But it has to be related in some way to to your disability claim, and also they need to usually let you know about it. They will usually let you know about it. I say usually because I can't say 100%, but most insurance companies are going to let you know about it when they're ordering this stuff. Definitely a chiropractor, that's the kind of thing that they would want to have the records. Chiropractor, physiotherapist, psychologist, etc. So they will usually just write to these people and request the records. But you are usually going to know about that, right? And quite often, if they write to any of your professionals, they're going to tell you that I got this request from the insurance company type of thing. So just keep that in mind. I don't want people to think that it's common for insurance companies to be sneaking around, digging into all your records and things like that. That is not a common practice. I'm not saying it would never happen, but it would be quite difficult for them to do it anyway. Like I told you, if they want, for example, if they had one of these broadly worded authorizations and they wanted to try to get your tax records, let's see what's going on. Revenue Canada will not accept that broad authorization. So it's not going to work. Like, they can try, but Revenue Canada is not going to accept it. So the practicality is that there are real limits to these broad authorizations in allowing them to do this like sneaky investigation. What these broad authorizations allow them to do is administer your claim without the fear that they're going to somehow they're going to talk to this agency that arranges IMEs and you didn't authorize that. Oh, now they breached it. You're going to put in a complaint. Like, that is what they don't want to be dealing with that. So that's why these broad authorizations can capture everything. It allows them to administer the claim. The things that you would want to be where you might put, clarifications are around not giving certain information to your employer. Like, that's the big one where people often don't want that. And the insurance company knows that. So you clarifying that is going to be fine with them. They have to have some level of talk with your employer, but you can limit it that they're not to give them medical records and that kind of stuff. Okay. From Jason, what triggers an insurance company to conduct surveillance? So there are many reasons insurance companies will do surveillance. Normally, what will trigger it is if there is some red flag from their point of view, that there's something from their point of view that is not adding up. Or that will often be a situation where you have an invisible illness that is, the doctors are kind of perplexed about the severity of it. They're not quite sure what the diagnosis is. Basically, something that you could be faking. Those are situations where if you have a very ill-defined, not a well-defined illness and disability, and nobody's sure what's going on, that is a situation where you could see surveillance. It also, if there's red flags, like you are saying you have a certain level of disability, but then you've got a Facebook feed full of you doing things that on the surface appear to be contradictory, then that is another situation where they might do surveillance. You'll see surveillance more in cases where the money involved is higher. So if you have a higher disability benefit, then you're more likely to be under surveillance because they have more at stake. There's more, it's worth it to them to spend, because surveillance isn't cheap. And I one of the things you realize is that people think insurance companies, because they make millions and millions, they will spend unlimited amounts on their cases and hire the best lawyers and all that. It's actually not true. They don't hire the best lawyers all the times. They hire the best lawyers for the cheapest. So the cheapest, best lawyers, but they're not necessarily going to hire like the top lawyers. They want younger. So you'll often see lawyers with insurance companies. There are very many good ones, don't get me wrong. And they will hire more senior lawyers, but often they prefer to get more junior lawyers who are cheaper. Everything about an insurance company is about saving money. And so even the lawyers that work there will complain to say they don't have the resources. Like a small firm like mine will have more resources than these big insurance companies make available to their lawyers. Okay. So just keep that in mind. There's often this misnomer that the insurance companies, they're going to spend all this money. No, they're quite cheap. So why I'm saying this is that they don't just do surveillance on every case, because surveillance is not, it's not cheap. It costs thousands of dollars to get surveillance. And if you take thousands of dollars, multiply it by thousands of claims, you're now into millions of dollars on surveillance. They're not going to do that. They're going to pick and choose their cases. They're going to look at cases where they're paying the most benefits and have the most future benefits that would have to be paid. Those are ones where you'll see surveillance, or situations where, honestly, sometimes they do it because they have nothing else. Like, all the medical evidence supports you, but for some reason they doubt you, and they will, in those cases, try to come up with a way to do surveillance. I'm going to do a whole episode on surveillance because surveillance is not straightforward. There are rules around it on what the insurance companies can do, and they have had their knuckles rapped a few times by the Privacy Commissioner of Canada for doing surveillance inappropriately in these insurance cases. So it's just not, they're not allowed to just go wide open and do surveillance unlimited in any way possible. There are a lot of limits on it because they also have that good faith obligation to not do surveillance unless there is a good reason to do it. All right. Another question about surveillance from Patricia. Hi, Patricia. Speaking about surveillance, my property backs onto a cemetery. Can their investigators watch me from there? Can they sit in the parking lot of the townhouses near me? Yes. So they can conduct surveillance from any public area. So I don't know if the cemetery would be considered a public area or not. That would be a kind of a up in the air. But in theory, yes, as long as they're on a public space, they can't trespass onto your property to do surveillance, but they can go right to the edge of your property. So the sidewalk in front of your house is public. They can do surveillance from any public space. They can even look into your house, although there are some limits on that. They can look into your house as long as they're looking in from a public space, but that's starting to cross the line a little bit, and that may get them into trouble, peeking in through your windows from a distance with like a high-powered lens or whatever. You can use, I've heard of drones being used to like get up higher to see over fences and different types of things. I was once involved in a case. It wasn't my case, but where the insurance company hired a plane to do surveillance because the client lived quite in a remote rural place, and they were convinced that this person was farming. So they hired a plane to do like aerial photos to see if try to get photos of this person on a tractor or doing whatever. So that is another area. So yeah, they could fly over and try to take shots from above. They have to be on their own in public. So if you're out, that's why surveillance is easiest to do when you're all out in public. And oftentimes how surveillance works is they will do it one of two ways. They will either stake you out at your house, kind of like you see in the movies, and wait for you to leave and then follow you somewhere. And then it's easier for them now because you're in the public domain. Or if they know you're going to be somewhere, they will just sort of set up ahead of time at that place, sort of like an ambush, and just watch you when you get there and then follow you from there. All right. Now, the parking lot in the townhouses. So if the parking lot is a public space or a quasi-public space, possibly they could. It's not, as long as it's not your property, it's less of an issue. But generally, if they want to do it by the book, they're going to want to be in a public space. All right. Audrey says, thanks. You're welcome. Menia is testing things out. That's fine. You got your test in to go ahead and ask us a question. How long are authorization forms valid? That's a good question. So if it doesn't state on the form how long it's valid, usually a year is a good rule of thumb for how long a form might be valid, but it would be a question of fact for a judge to figure out later if there was a dispute, or the privacy commissioner to figure it out. Generally, they're going to err on the side of like a form they're going to err on the side of protecting privacy. So if it's not stated explicitly how long it's to last, it could be a one-time use. So if you gave an authorization for your doctor to disclose something and there's nothing on there, it depends on the wording of it, but it's not going to last forever. It really lasts as long, like the authorization is meant to be your expression. So it lasts as long as you intended it to last. And they do the wording of the form, so it's harder to see what the intention is there. But if you're signing a form, you have to read it and see like, what's the intention here? How long is this supposed to last? And that is how it would work. So there's definitely no right answer of how long it will last. You'd have to look at the context. Some forms will say it expires, but certainly we even run into problems where we will have like we have open broad authorizations that clients sign for us because it makes it easier for us to gather information for their case. Now there's more trust client has more trust in us than an insurance company, but we will send out our broad authorization to a doctor and they'll say, no, I don't want to use this because it's a year and a half or 2 years old. So sometimes we have to go back and get the client to sign a fresh one. All right. One of the forms showed section 9.h, let the insurance company know where I'm leaving the company, country, or traveling. If there isn't a clause in the policy, but it is added under one of these forms, is the claimant obligated to let the insurance know when traveling? Your obligations to the insurance company, like your legal obligations, are in the policy. So they can try to get you to agree to new things that aren't in the policy by saying, I agree, like you said on these forms, I agree if I travel, I'll let you know. Again, these are dubious whether that has any legal effect that you agree to this, because they're not really giving you anything in exchange. The first thing you learn in contract law in law school, first year, is that for there to be a contract, so therefore for there to be an agreement, there has to be three things. There has to be an offer, an acceptance, and consideration. Consideration means something of value is given back and forth. If something of value is not given back and forth, then something is just a gift. It's not a contract. So there have to be, for a contract to be binding, there have to be obligations on both sides, and both sides are getting something out of this. When they just send you a form like this, asking you to agree to these things, there's not really, it's hard to hold you to it because they're not giving you anything in exchange, nothing new. So again, like they can ask these things. A lot of them aren't legally binding, but they're still just unnecessary for them to ask you to sign. So the long answer to this is it's always a good idea to tell them when you're traveling out of the country, regardless of whether it's required in the policy or on one of these forms. I would tell everyone, and that's going to be a future episode. We'll talk about travel, but long story short, if you're going to travel, I would get out ahead of it and let them know whether you're required to or not. So you could easily just cross out the form where they're trying to get you to agree to this, but I would still encourage you to actually tell them that you're going to be traveling, just to get out ahead of it. All right. All right, here's a question. Can SSDI be garnished? Okay. I will tell you that I know from SSDI that is the American Social Security Disability Income. I'm a lawyer in Canada, so I'm not able to tell you. I wouldn't be able to tell you whether that could be garnished or not, unfortunately. But there are shows where you could go to that. What's the name of the lawyer? Oh, I can't think of his name off the top of my head. There's a lawyer in the US that does a live stream like this, I think once a week in the evenings. What is his name? If you just go on YouTube and put Social Security Disability Lawyer, his YouTube channel pops up. So just look for when he's doing his live stream and you could go there and ask him and he would be able to answer it 100%. All right. Let's see if there's any more questions. How are we doing for time here? Oh, we're not doing too bad. So let's move on to our next thing. Oh, whoops. That was supposed to be up on the screen while we were doing our questions and answers. All right. Let me plug my book. I'm not going to become a millionaire off this book. In fact, we give it away for free. But this is my book on long-term disability. I would encourage anyone here to go get a copy. You can get a copy by going to the description down below this video, and there's a link where you can go and order a PDF copy of this book. This is the newest edition. I first wrote this book back in like 2015, I think, something like that. I wrote one, and then I quickly just did another version of it. This is kind of the third version, and this version's really been improved and extended. It's a copy of it right here. This is what it looks like. So it's a smaller book. Probably how many pages? 180, 190 pages. And I'm pretty proud of it. Not going to lie. I put a lot of effort into this book. The kind of things that we'll go over, I'll just show you here briefly. Now, like I said, you can download it for free on our website. It was just published this year, 2025. The things you'll find in this book is I do go through the key point of the book is the 11 mistakes that will ruin your disability claim. I know that's a little dramatic, but hey, you got to get people's attention, right? So let's take a peek here. These are the sections of the book. You can see overview of employer-sponsored disability plans. So this book is written for people who have group benefit plans through your work in Canada, in case there's any Americans on here. So I go through all the types of employer-sponsored plans because that can matter. There's a section on how to apply. There's a part here on how claim decisions are made about you, so you can understand how they go about making decisions to approve or deny your claim. Part 5 deals with claim denials and appeals. Part 6, I talk about everything that happens after your claim is approved, like retroactive monthly payments, offsets and overpayments, kind of what the person was asking about, the SSDI. Continuing disability reviews, a surveillance is talked about in here, return to work programs. I talk about lawsuits and settlements. So if you get involved with lawyers, what happens with lawsuits and settlements? And then part 8 is all these mistakes. I won't go through them all, but they're listed in here. 11. I don't know why 11, but 11 was a good number. And what I'll do is part of what we'll cover, we do long-term disability every Tuesday. So I'll probably be starting to cover some of these mistakes. We'll go through all these mistakes over the coming weeks. And yeah. So let's see, is there any mistakes that are relevant today? Not really. And then at the end here, it just talks a bit about our firm, the next steps, and that type of thing. All right. Okay, we got another question here. Patricia asks, on the forms, it asks if you're able to work under specific conditions, such as exposure to dust, fumes, gases. I said no without PPE, as it is an untested environment and situation. Is that okay, or should I state something else? No, that's fine. But again, one of the things you can do with these forms that people don't realize is whenever you get these questionnaire type forms and they're asking you to check A or B, this is why I like doing it like with a pen, doing these forms in pen and paper, because you can go and you could check both and then write an explanation, because sometimes it will be A, sometimes it will be B. So I like, messing up the focus. I like it when you can put notes. That's the problem with these online forms. With online forms, they will lock you into very narrow, answer yes or no. You have no room to say, well, it's not really yes or no. So in that type of situation, I think what you put is fine. And could, if you needed to, you could put an explanation right on the form. You can write on these forms. You can attach pages. All that is legal to do, which is a good reason to do these forms paper-wise and not do them electronically. Electronically, it is very hard. You're limited to exactly what is there. And sometimes you do want to be able to give more information. All right. This is a great question by Jason. How does one keep LTD for as long as possible? It is really simple. So to keep LTD for as long as possible, you need to, the insurance company has to believe that you meet all the criteria and that you are acting in good faith, and they believe you. Okay. So to make sure that that is the case, you really need to be someone who is cooperative with the insurance company and getting them all the information they need. Sometimes it's out of your control, but what you can control is that you're cooperative with them, that you're doing things in good faith. If they're asking you for stuff, you're getting it. These are all the things that will put you in more likely to be approved by you being cooperative and getting them what they need. And oftentimes that's what's in your control. What's not in your control is what your doctors say. It's not in your control how they view you or the nature of your disability, these kind of things. So sometimes there's nothing you can do that will prevent them from at some point wanting to terminate your benefits. But the things you can control are maintaining your credibility and believability and being cooperative with the insurance. And the other thing that's in your control is attending all treatment. So it's very important that you be seen as somebody who is doing everything possible to get better. Following the advice of your doctor is critical. Not missing any appointments for anything, or very limited missing appointments, and trying everything that's been suggested. Those are the kind of things that you have to do in order to have the best chance of possible to making sure your case continues to be approved. All right. What's this one say? I wondered if this is Audrey. Thanks, Audrey. I wonder if you might consider doing a webinar on returning to work. What's involved? Time limit to go back on LTD? Yes, that is a great topic. So let me write that down. I'm going to write that down. Return to work. Okay. And what's involved? Time limit going back. So this person wants to know like a return to work program from being on LTD. Then what happens if you have to go you go back to work, but then you might need to go back on LTD, that kind of thing. Yeah. Back to work. I don't think I have a topic nailed down for next week, so that can be our next week's topic, tentatively. I will talk about that next Tuesday. All right. See if we got any other questions here. We're getting near the end. All right, folks, thanks for joining me again today. I'm still learning, though. This is a new format for me to do these every day. So far, things are working. A little snafu yesterday with no sound, but we got over that today. And like I say, we'll be coming back here tomorrow with talking about an employment issue. And it will be, when can employers fire someone who's out on disability leave, and what are your rights? And I'll look forward to seeing you guys. I do have to run for now. So if I didn't get your questions this time, just come back next time. We'll be here every day this week. I'm still trying to do the call-in show. I don't know if there'll be some brave person who'll be able to call in and come on live so everybody can hear. But certainly that is something that hopefully someone will be able to do on Thursday. If not, I'll have other contingency plans of things I can do in case there's no one that wants to come on the air. But hopefully we will. Once we get some brave souls doing it, it will probably make other people more comfortable to come on. All right, folks, that's it. I'm going to let you go for now. I wish you all the best, and we will see you back here next week.